Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Today we're going to talk about Murthy versus Missouri, which is a case that involves censorship. Now, I don't believe in censorship. I think the remedy for bad speech is more speech, and I think it's odious when the government sticks its hand on the scale and decides what's truthful and what's false. I think that we're all smart enough to kind of figure that out, and because of that, I'm very much opposed to censorship. Not long ago, the Twitter files were released after Elon Musk took over Twitter. Well, of course, he renamed it X, and now everybody doesn't know whether to call it old Twitter or new X. I think that's kind of funny. It's almost like the branding of New Coke. You remember how that was such a confusion for people, and you didn't really know what kind of can to go in and look for when you went into the store? But the funny thing about all of this is, once he took over, he released all of the information and all of the communications between the federal government and Twitter. And all of that communication had a lot to do with shutting down certain lines of thought on Twitter about things like vaccines, about the election, about the now infamous Hunter Biden laptop, which was supposedly the creation of Russian disinformation in which the government just recently used to convict Hunter Biden. So lots of things that started out as misinformation didn't wind up as information. And because of the Twitter files, the attorneys general in Texas and Missouri, along with 5 private plaintiffs, sued, among other people, the Surgeon General, Vivek Murthy, whose name is on this case, for essentially engaging in sort of a puppeteer act to censor the free speech of Americans. Now, Justices Thomas and Alito, when this case came before the Supreme Court, I think were justifiably outraged that the government would do through an agent, in this case Twitter, Facebook, Instagram, that which it could not do directly. In other words, the FBI can't come to your house, knock on the door, and say, hey, we don't like what you posted on Twitter, and as a result, we're taking your computer away. They couldn't do that because it would be censorship and it would be in violation of the First Amendment. So what the FBI did was it went to Twitter and said, hey, that crazy DeWitt guy that posted that stuff about whatever, take that down. And indeed, that's what happened. Twitter acted on all of those requests from the federal government. But from the moment that this case started in oral argument at the Supreme Court, you knew that the federal government was going to essentially get away with this censorship, not because censorship was somehow right or valid or the misinformation needed to be censored in some way, but rather because the plaintiffs had violated the cardinal rule of all litigation. They did not have standing. Now, I know I've said it 100 times on here, maybe, that you got to have Article 3 standing, and that standing revolves around the following. There has to be a case or controversy. In other words, there has to be a real dispute between two parties. It can't be a dispute that essentially is made for litigation. A challenges B basically so they can set up a rule. Federal courts can only review statutes and executive actions when it's necessary to redress or prevent actual or imminently threatened injury. In order to get there, the plaintiff has to show an injury that is concrete, particularized, and actual or imminent. And here is how the court phrased it in the case. A proper case or controversy exists only when at least one plaintiff establishes that she has standing to sue. She must show that she has suffered or will suffer an injury that is concrete, particularized, and actual or imminent, fairly traceable to the challenged action and redressable by a favorable ruling. These requirements help make sure that the plaintiff has such a personal stake in the outcome of the controversy as to warrant her invocation of federal court jurisdiction. In other words, if, for example, someone has come over to your house every Friday night and, thrown a brick through your window, well, the fact that they've done it in the past 2 or 3 times may indeed mean that they're going to do it again tomorrow. So you could theoretically get an injunction against them because the harm was imminent. But of course, for the damages from the first 2 or 3 bricks, well, you would have a concrete and particularized injury from that. The injury must be fairly traceable to the conduct that's been challenged. In other words, it has to be related to what you're suing over, and it has to be capable of being redressed by a favorable ruling, an injunction perhaps to keep the person from coming back to your property. So this is how standing looks in your average case. Let's say an assault case. A comes over to B's house, rears back, cocks his fist, and pops old B in the kisser. And as a result, B has a concrete injury, and he can sue under Article 3 of the Constitution, assuming that the damages are meeting the jurisdictional threshold. This is just an example. It's not likely to be in federal court, but these are the principles that underlie standing. Now let's change things up just a little bit. We have C here, and C is one of those pot stirrers, one of those troublemakers, sometimes called Karens or Chads or whatever, and he just doesn't like B. He thinks B is kind of a nasty guy. So he goes to A, who he knows is the kind of guy who can right wrongs, and he says, "Hey, man, dude, you need to go over there and kick the beans out of old B." And A does that. So A has hit B, he has a concrete injury, and he can sue under Article 3. C has conspired with A. B has a concrete injury from that conspiracy, and he can sue under Article 3 too. This is classic standing under Article 3. But let's say that now, because he's been beaten up, he would really like to avoid being beaten up again. So he knows he has causes of action against both A and C, but not against C for actually hitting him. He has a cause of action against him for conspiring with A. So over here on the left side of the diagram, if B sues C because he conspired with A, but he doesn't sue A, who actually did the beating, he can't get an injunction against C to keep him from conspiring because we don't know whether or not that would actually prevent A from attacking him again, because maybe A has an independent reason to attack. As a result of that, because you can't prove that it's fully redressable by an injunction, you don't have standing. Now, on the other side of the page here, we see B suing both A and C. Well, now, because both parties are before the court can issue rulings against both parties that will be effective. He can say to C, don't conspire, and he can say to A, don't attack B. And in that situation, you do have a redressable injury and you have Article 3 standing. So in this censorship case, this is the actual standing of the parties here. We have Missouri and the state of Texas by their attorneys general and 5 individual private plaintiffs suing Dr. Murthy for what Twitter and Facebook and Instagram did. Do you see the problem? They want an injunction against these government officials to keep them from telling Twitter to interfere with their free speech, but Twitter is not in front of the court. And as a result, the court would have to guess as to whether any action it took would be effective against the actual platforms, because the platforms ultimately control the content moderation policies and actions, and that was what was actually interfering with their free speech. So because none of the platforms were in front of the court, there was no standing. Now, this is basic Article 3 law. This is not, and it should not have been confusing to any of the people at the district court level, at the Fifth Circuit level, where they modified the injunction basically on the basis of standing. And there is a good reason why the Supreme Court took it, because there simply was no standing here to enforce an injunction against the people in the government when, in fact, the actual content moderation and the censorship was being done by the platforms itself. the importance of this case is not that it held in terms of standing. The importance is buried in the concurrences of the judges who come back and say, this is terrible because now we have the government doing through an agent what it could not do itself. There needs to be some way of redressing this. Although they never come right out and say this is a situation where we ought to make an exception to the standing rule, because the standing rule has been hard and fast since the founding of the country. They are clearly bothered by the fact that the government gets to put its hand on the scale in terms of those content moderation policies. And so, if there was something that was traceable to a discrete action by a certain member of government, Dr. Murthy, for example, if you could show that Dr. Murthy sent an email and it caused your post to get taken down, and you could get testimony from the person who took that down that the only reason they did it was because Murthy had told them to, then you might very well have standing to bring an action against Dr. Murthy for injunctive relief against any future actions like that. But even that is attenuated because, again, you're counting on the platforms not actually having content moderation policies that they would act on their own. You see where this goes, which is we have a violation of somebody's free speech rights through action of the government putting its thumb on the scale of justice, and we have no effective remedy. Well, if you need a remedy for something like this, it's called Congress. And you have to go to Congress and say, hey, you need to fix this problem. You need to amend Section 230. You need to create a right of action, a private right of action, so that individuals who are affected by any kind of intrusion on their free speech rights have a right to go after the platforms to stop that. And there's good reason to do that, even though all of these are privately owned. I mean, Facebook has made Mark Zuckerberg a quadrillionaire, I think, at this point. Even though they have private ownership and privately they ought to be able to do what they want, the fact of the matter is they've created a public forum. And the public forum rides on an internet that was designed and built by the federal government. Now, everybody uses it, but it was originally set up by the government. And as a result, I believe that you could craft a statute that would require them to respect people's free speech rights. And by respecting free speech rights, I don't necessarily mean that you ought to force everybody in the Twitter sphere to read stuff that they don't agree with. People who are of Jewish faith should not be exposed against their will to essentially anti-Semitic propaganda. So there are ways that these platforms can be segmented such that people can set up filters so they don't have to see things that are upsetting. In fact, YouTube has the very same kind of filters here and does a really good job, I think, of making the experience of a YouTube user such that they can find information they want and avoid information they don't want. That's what the problem is. That's what was discussed in Murthy versus Missouri. And although I would very much like to see some limitation on these platforms being able to censor speech, I also think that in this context, the court absolutely got it right. If you have any questions, drop them in the comments down below. Like, share, subscribe, all that stuff we ask you to do. You can always feel free to email me at the address above. And if you have the opportunity today, do something nice for someone. Go out of your way a little bit, maybe open a door, who knows. Do something nice, and then come on back tomorrow. Join me down here at the beach. We'll talk about something else that you'll find interesting. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.